Brian Lehrer on WNYC. Now we'll turn to a new law that took effect in New York State last Wednesday, a decade after it was first introduced in Albany. It's the Medical Aid in Dying Act. And what it does is give terminally ill adults with 6 months or less to live the legal right to request medication to end their lives kind of on their own terms. Now, there are definitely conditions that they have to meet, but that's the basic of what the law does. New York joins a dozen other states and Washington, D.C., where this option exists. We've covered the debate over this law on the show over the years. Today, now that it's been enacted, we're going to talk about whether or not this option would be right for you or someone you love, and how to figure that out. So we're just going to help you understand the law, who qualifies, how the process works step by step, where it fits alongside hospice and palliative care, how some of the concerns about coercion, people being coerced into this if they don't have a lot of power in the political or legal or medical system, can navigate that risk, with two people well suited to walk us through it. Amy Paulin is the New York State Assembly member representing the 88th District, that's in Westchester, chair of the Assembly Health Committee, and the author and Assembly sponsor of this law. Also, David Leven, executive director emeritus and senior consultant at End of Life Choices New York, an organization that counsels patients and families on exactly these decisions. Assembly member and Mr. Leven, welcome back to WNYC.
Thank you so much.
Thank you for having us, Brian.
Assembly member Paulin, now that the law has been passed and there were negotiations and changes along the way to the final version, just say in plain English to our listeners in New York State, what exactly does this law allow and who is eligible?
If you are within 6 months, or if a doctor says to you, typically a cancer patient, that you only have 6 months to live, you are eligible. If you have a terminal illness that's going to result in death within 6 months, you are eligible for MAID, as we call it, medical aid in dying, to be able to self-ingest medication that would end your life.
And so, David, a question about the language, as the Assembly member just framed it. Obviously, we're saying medical aid in dying in this segment, and that is the term in the law. Listeners have also heard assisted suicide, death with dignity, right to die. Are those all the same thing? Should we think of them as all the same thing?
They are absolutely not, Brian. Suicides are usually done by people who could continue to live, who have a mental illness, but they choose not to continue to live. Often they are done impulsively and violently and without consultation with others. On the other hand, medical aid in dying is only for people who are dying. Their disease is killing them, and they're going to die in the very near future. And there are many people involved in the process, including at least 2 doctors, both of whom have to determine that the person is terminally ill and likely to die within 6 months, as Amy mentioned, and also have decision-making capacity and can self-administer the drugs. There also has to be a psychiatrist, psychologist, or neurologist involved in the process who makes the determination that the person has decision-making capacity. And usually the process takes several weeks from the time that the request for medication is made until the time that the patient actually takes the medication, if they ever do. And about 35% of patients never, in fact, do take the medication. So for these patients who actually would prefer to continue to live but can no longer do so, and it's only a matter of how they're going to die, this is a choice which enables them to die on their own terms, as you mentioned earlier. And for them, unlike assisted suicide, where the event is usually tragic, this is self-empowering for the patient and usually for family members as well.
Listeners, we're inviting your questions about New York's new medical aid in dying law and how it works. This segment is not for having the debate anymore. We had it multiple times over the number of years that it was in the legislature being considered by the legislature. Now it's the law. And so we are just inviting your questions with how to consider this, if you think you might want to consider this now or, just hypothetically in the future, for yourself or for someone you love. 212-433-WNYC, or maybe you've even been through this process with a family member in New Jersey or another state where it's already legal, and you can give people who might be considering it in New York some advice about what to do, what not to do, and what it was actually like, what to be prepared for emotionally. You just heard David Leven say, you don't even have to go through with it once you're authorized. 212-433-WNYC. Call or text your questions to 212-433-9692. And David, let me continue with you and right on that point, because your organization counsels patients and families on end-of-life decisions within the context of a law like this. So say someone listening right now has a terminal diagnosis, or someone in their family does, and they want to explore this option. What's step one?
Well, step one might be that they talk with us if they're interested, and we can tell them what the process is and what they would have to do, because there are many legal requirements in the Medical Aid in Dying Act as well as safeguards. And otherwise, they might just speak with their attending physician to see if he or she would be willing to take care of them at the end of their lives and prescribe the medications which would be necessary for them to end their lives through a pharmacy which would prepare those medications, and it has to be a compounding pharmacy. And they should understand, of course, that there is a request process that they would have to go through, both making an oral request to their physician or by video, and a written request as well that would have to be witnessed by two different people, neither of whom could be a relative or an employee of the healthcare facility where the person might be at that time. And the two witnesses could not in any way benefit as a beneficiary of the estate of the person, or financially, or in any way from the death of the patient. And they would also have to determine that the patient has decision-making capacity and appears not to be in a situation where they are being coerced. So there is a real serious process that has to be followed. And then there have to be two doctors who make the determination that the patient is terminally ill and has decision-making capacity, followed by a psychiatrist, neurologist, or psychologist who makes a further determination of decision-making capacity.
Faye in Riverdale, you're on WNYC. Hello, Faye.
Hi, thank you. I'm curious about someone diagnosed with Alzheimer's disease or any kind of dementia. I consider it a terminal disease, though it's not the killer itself. If the patient is compos mensa and can give consent, then they're going to live more than 6 months. If they're not, then they can't give consent. So I don't understand this conundrum and the law.
Assemblymember Paulin, would you address this caller's question? You could see
Sure.
where it comes from.
Yes. Although I'm very sympathetic to the plight of someone with Alzheimer's, they would not qualify under the definitions that we set out in the law. So it's unfortunate. I get the problem, but they are not qualified. We modeled this law after Oregon and all of the other states that have already enacted medical aid in dying, and all of them are consistent with that definition that I described.
So that's to say that somebody with Alzheimer's or any form of dementia would be considered incapable of making an informed decision on their own, and nobody is allowed to make that decision for them?
Partly, also, they're not going to die within 6 months. So, you might think that their mental state means that, in a sense, they've died to the family members, or uh, but they're not going to. They're going to physically be able to live. So there's a double problem there.
Well, what if they have some other terminal illness, but they also have dementia?
Interesting. If they have a terminal illness, then yes, they would be qualified, but not if they are not mentally able to make the decision for themselves. So it's unlikely that they would qualify, but I would imagine mild dementia, mild Alzheimer's in the beginning stages, you still have capacity. So it really would be dependent and situational.
David, we should note that participation is voluntary for doctors, pharmacists, and hospitals, not just for the individuals. And a lot of health systems are still writing their policies. Actually, council member, assembly member, let me stay with you on this. Why did
Sure.
you make it voluntary in the law
Um,
for doctors, pharmacists, and hospitals, not just the individuals?
that was very important for my colleagues to feel comfortable uh, with the ultimate passing of this provision. This bill. It's also consistent with, again, the other states. No one has to participate in this if they don't want to. Obviously, the patients don't have to do this, and certainly providers. If they have a religious belief that means that they don't want to even participate in counseling a patient, they don't have to do that.
Let's take another question from Lou in Newark. You're on WNYC. Hi, Lou.
Hi. Yeah, I didn't catch the beginning of the show, but I work with ALS and spinal cord injured patients, and I'm just wondering if someone is unable to. Is it for only patients that can self-administer the medication, or can someone do it for them if they're deemed to be within 6 months? ALS can be if their breathing is really severe. Spinal cord patients can linger for many years, but many times they want to just give up and say, I want to end it, but they can't take their own medication. So is this only patients that can administer? I heard that at the beginning of the report I picked up.
Yes, it's only for
Go ahead,
patients.
Assembly
Yes,
member.
it's only for patients that can self-administer, but self-administration and absorption into the body can be in many ways, in many forms. So ALS is a very common diagnosis across the country. 4 states, again, that have legalized this. It's second to cancer because of its terminal nature. So there are ways to self-administer these medications that would not necessarily preclude someone with ALS.
And Monique in Tarrytown. You're on WNYC. Hi, Monique.
Hi, thank you for taking my call. I'm calling to follow up the issue about forcing religious workers to compromise their faith, because there's a lawsuit that was filed back in July. It's a coalition of healthcare providers, Catholic ones, that are suing New York State on the new assisted dying law. What is the status of that? And is it very clear that, my neighbors are the Dominican Sisters of Hawthorne, who run the Rosary Hill Hospice, which care for the dying. They don't take any money from the taxpayers. So are these just rebel nuns that didn't understand the law, or what's the nuance?
Assembly member, I'll stay with you on this one.
Sure. So I've read the lawsuit. I believe that we will prevail. The claim is that, again, that someone with a strong religious belief against these, the implementing this law in any way are going to be forced to do so. And I believe the law is very clear that they don't have to participate, and that we even have a section that says they're not liable if they don't participate. So we have strong provisions in the bill that will allow any provider who has a religious belief to exempt themselves in any way. And I believe that the court will see it that way, but obviously it's got to play itself out in the court system.
David, do you want to weigh in on this?
Sure. As a retired lawyer, I completely agree with what Amy has said. No one has to participate in this law in any way. They're claiming, the nuns and their different orders who brought this lawsuit, that they would be required to provide information and counseling to patients about medical aid in dying, but they're not even required to do that under the law. And I think that the court is going to agree with that defense and ultimately dismiss the case. I understand their concerns about not wanting to participate in any way, but they really don't have to. And the court has just issued a temporary restraining order that only applies to the plaintiffs in the case, which makes it clear that for now, that they don't have to participate in any way, even though, again, it seems to us that the law is perfectly clear on this point, so that ultimately we expect the case to be dismissed.
David, a listener writes, if a terminally ill patient has a guardian appointed for them due to lack of mental capacity and already has the authority to make healthcare decisions as part of that guardianship, does that guardian have the authority to give the consent for the patient to engage in what the listener calls assisted suicide? I think you've already answered that question, but we're getting various versions of the same question. I think the answer is no, but clarify that further if you would.
The answer is absolutely no. No one can make this decision except for a person who has decision-making capacity. So a healthcare agent cannot make the decision, nor a surrogate, nor a power of attorney. No one, except for the individual, him or herself.
Alexander in the Bronx, you're on WNYC. Hi, Alexander.
Yeah, Brian, how you doing? Where is the judicial intervention in this entire process? Who's to determine whether or not a person is actually being coerced, or suffers from Alzheimer's and they're not making an intelligent decision, or whether or not someone is financially benefiting from this? That's the purpose of a judge. You can't have the people in the medical profession making this decision. There should be specially trained judges that are completely familiar with this entire enterprise, that go and interview the person and interview the parties and then issue a written decision. Where is the judicial intervention here? Can you please answer that question?
Assembly member.
We don't require judicial intervention for any medical procedure, and we are not requiring it here. I don't know why you would imagine that a judge would have a better indication of someone's ability to self-administer or someone's terminal illness than their own physician. So there's no requirement in the law, in any of the laws, in any of the other 13 jurisdictions that have implemented medical aid in dying, to require the judiciary to have a role.
Are there ever situations?
And beyond that, there's...
Go ahead, David.
Beyond that, there is no evidence at all that there has been any substantiated case of coercion. There is no court decision that has found coercion. The former executive director of the Oregon Advocacy and Protection Agency, after the law was in effect in Oregon for 20 years, said there had not been one complaint filed about coercion or abuse of their medical aid in dying law. So that while we always have to be vigilant to ensure, hopefully, that there won't be coercion or any kind of abuse, to date, we have no evidence that this is a problem whatsoever.
One more. Edith in Manhattan. You're on WNYC. Hi, Edith.
Hi, everybody. Thanks. This is a really good segment, as usual. but I have some skin in the game. My mother just turned 92, healthier than me, lives in Vermont, that Vermont living. But I have a question, just very specific. What are the methods, the medications and the method of self-administration if someone is cleared and does choose to end their own life? What are the medications and how do they administer it?
David, why don't you take that one?
There is a protocol of a group of different medications that are used to ensure that the person is going to die peacefully and relatively quickly, usually within a half hour, on average to 2 hours. And what we have found is that over 5,000 cases where people have actually taken the medications, that it works extremely, extremely well. So pharmacies, which are compounding pharmacies that have to prepare these medications, are able to do so. The person gets the prescription, although they have to wait 5 days after the prescription is written before it is filled. Again, just to make sure that hopefully the patient is going to want to continue to end their lives in this way. But it seems to work extremely well in the states that have authorized medical aid in dying now for many years, in Oregon for just about 30 years. And by the way, I should mention too that about 90% of those who die by medical aid in dying are receiving hospice care, which is considered to be the gold standard of end-of-life care. And hospices really provide great benefits to try to ensure that people have the best quality of life possible as they're dying. But still, for a small number of people, hospice is not sufficient to adequately control their suffering. So there will be a small number of people, about less than 1% actually, in states that authorize medical aid in dying, who will end up taking the medications. But at the same time, it gives great comfort to people to know that they have this option available to them if they should need it.
David Leven is Executive Director Emeritus and Senior Consultant at End of Life Choices, New York. Amy Paulin is the New York State Assembly member for the 88th District in Westchester and Chair of the Assembly Health Committee. New York's medical aid in dying law took effect last Wednesday. Assembly member and David, thank you for answering people's questions now that this is actually in effect in New York.
Thanks, Brian, for having us.
Thank you, Brian.